that representing yourself is a terrible, terrible idea, because you will be required in any proceeding to know all of the rules and everything, just like the lawyers. You have to follow the rules of evidence, the rules of Texas evidence, the rules of Texas criminal procedure. Whether you think they apply to you or not, they're going to apply in this court. So what happens is, if you get in front of me, it's one thing. We can have this little bit of patience and I'm going to go, but you get a jury in there. And if you want a jury trial and you want to present a case to a jury and you're not doing it right, it's just going to get worse for you. I'm going to have to shut you down. I'm going to have to not let you enter certain documents in if you don't know how to do it properly. You're not going to be able to question certain witnesses if you're not doing it properly. So it's really, really a terrible idea to represent yourself. If you insist on that, I can go through some questions, but I'm assuming, am I correct that you don't have any formal legal training? Have you ever been to a school or any kind of legal training? Okay, so then am I right to say that you don't know what those rules are and how to pick a jury or enter in evidence certain items at a trial and things like that, correct?
Yeah,
You do know how to do that?
to a degree, yes, I do.
So you would know how to properly, under Texas law, pick a jury and go to trial. All right, this is cause numbers 26 DCCR 0322 and 0323. And you're Nasir Brown? Are you going to answer out loud or no?
Sorry, I'm just going through some things right now.
Okay, so I just need to make sure, obviously I recognize you from being here before. I'm also going to take judicial notice of the court's file, and including a letter that you wrote to the court. In that letter, it does state from you that you were XREA-REL or REI, I can't read it, but anyway, Nasir Lewis Brown. So you're telling me that at one point in this letter you were Nasir Brown, and so Mr.
No relationship.
Mr. Rojas, what is the announcement?
Judge, Mr. Brown has told me on 2 different occasions now that he does not want a court-appointed attorney. He wants to represent himself. And I think he wants to address the court about that this morning.
I go by Mujahid Bailiff. That's the
fine.
Name. That's actually who I go by.
That's fine.
Nasir Brown is a thing of the past.
Well, and here's the thing, unless you've changed your name, and I'm going to respect that that's what you want to be called and that's what you have.
That's what they want.
And that's who you are, but that if you have not changed your name legally, then I have to go by that legal documentation in the state of Texas, which is driver's license, identification cards, and what you were previously known as. So let's just get past what I'm calling you and let's deal with what the cases are and what we need to do about those, okay? So for purposes of what you want to do in the future, what Mr. Rojas is saying, that you want to represent yourself, I want to admonish you to a few things and then ask you some questions about that also. The first thing I'm going to tell you is, I'm going to tell you this, I didn't even know how to do it when I graduated law school. There's no way you know how to do that. And I'm telling you this for your own good. It takes practice and it takes sitting with people and learning and going to school to be able to really represent someone. I, as an attorney, and I bet these attorneys will tell you the same, if they were in trouble, wouldn't represent themselves. One of the first things we're taught in school, I was taught, don't ever think of it. If you represent yourself, you have a fool for a client. That's what our professors told us. Because you're not able to represent yourself even as an attorney. You should get another attorney. So I really, really strongly recommend that you let Mr. Rojas help you. Mr. Rojas is a great attorney. He understands this process. He has a good relationship with the district attorney's office. He will either get you the best deal, or if you want to go to trial, we'll get you an attorney, Mr. Rojas or someone else, that can take your case to trial. So if you want to go to trial, the first thing you have to do is reject a plea offer. So if Mr. Smith has made an offer, then you need to sign something that says, I don't want that, I want to go to trial. Mr. Rojas can get that this morning. It's not committing you to anything other than saying, I don't want to take that deal. I want to go to trial. I need that in my file so that I know why we're in trial. Does that make sense? So I need you to sign that rejection, and then we'll get your case set for trial, and we can talk about representation, whether or not it'll be Mr. Rojas or whether it'll be someone else who can get ready for trial as well, okay? So y'all go sign that, and then I'll go over everything with you in just a minute.
Judge, I think she's signing them up.
Is she?
I
Okay.
think so.
Hold that. Mr. Galmore, are you here for Mr. Galmore, Ms. Simmons? Micah Pal?
Oh, Micah, oh.
Good morning. How are you?
I'm good. How are you?
Good. Good morning.
Morning.
Good morning, sir. You're Michael Powell or Micah Powell.
Good morning.
And this is 25 DCCR 1522. Mr. Powell's charged with burglary of a habitation. And what is the announcement?
Yes, Your Honor, we received an offer this morning. I've relayed to the client. I've also given that information to Mr. Elmore. We're just asking to be reset on another announcement. Okay.
Okay, it looks like Mr. Galmore just was hired in late June.
Very recent. Yes, Your Honor.
Okay, any issues, Mr. Smith? Mr. Powell, I'm going to reset your case one more time. That'll give you plenty of time to go over everything with Mr. Galmore, Ms. Simmons, so that at that next court date, we'll see if we can get an announcement. All right, you can go back with the bailiff. Thank you, Ms. Simmons.
Thanks, Judge.
That's it.
Hey, look, I didn't put a fine on that.
Good morning, Mr. Parker.
Oh, I'm so sorry.
How are you this morning?
Good, sorry, good.
I'm here. Right, Ms. Holmes on Christina Rodriguez, Ms. French. Good morning, ma'am. Are you Christina Rodriguez? And this is 17-27256. Ms. Rodriguez is on probation for injury to a child, elderly or disabled individual. There's a motion to revoke that's been filed. There was a request for a competency evaluation. I'm going to take judicial notice of the court's file. Ms. Rodriguez was evaluated by Dr. Rapon. I've got that report dated June 22nd of 2026. The finding in that report is that Ms. Rodriguez is currently competent to stand trial. And so is there any other evidence with regard to competency?
No, Your Honor. No, Your Honor.
Then at this time, based on that report, I will find Ms. Rodriguez competent. And where are y'all on the case? And what's the announcement?
If we could do probably a couple more, it's more than likely this may need to lead up to a hearing. From our conversations with Ms. Rodriguez, she doesn't believe she's committed the alleged allegations.
Okay.
So
So you want just a couple of weeks, and then that way, if we're gonna have a hearing, we need to go through the motion. It's
Yeah.
still gonna get pushed back. So let's just do maybe a 2-week
That's
reset.
fine.
Okay, well, reset it 2 weeks. Ms. Rodriguez, Ms. Holmes will be out there to visit with you about your options, and then with the next court date, we'll get pleas of true or not true, and then see where we go from there.
yes, ma'am.
Okay, you can go back with the bailiff.
Brittany, I won't be here that week, but it's okay, I'll let somebody else take those, please, and then we'll go from there.
I think it's. Mr. Wilkerson, you've got Kevin Thomas.
Here's Connor. Hey, that's the one that was on the list. Yes. That's correct.
Morning.
Morning. This is.
Morning, Ms. Malvina. Good morning, sir. Are you Kevin Thomas? And this is 26 DCCR 0798. Mr. Thomas is charged with assault on a security officer. Mr. Wilkerson, what is the announcement?
Your Honor, Mr. Thomas would like to proceed to trial on his case based on the underlying facts of the incident. I anticipate filing a notice of affirmative defense. And so I will get that filed. I've also got a HIPAA release that Mr. Thomas has signed. I do need to, some time for those subpoenas to come back. So
So there was already a plea bargain rejection, it looks like, that was signed, June 16th, the rejection of 15 years. Any change in that offer?
Yes, Judge, I have inherited this case from Mr. Coleman. I put a note to myself, see if Mr. Wilkerson and I speak in lieu of some notes that Mr. Coleman left before he switched courts. Before he maybe jumps through all of those hoops with those subpoenas, I understand where he's going. I think I'm probably going the same direction. Maybe one more setting before we were to place it on the trial docket. Let him get those in the works.
Sure,
and
let's
that
do
might be
that.
Productive.
Get with Ms. Malfino now that she's on that case, see if there's any new negotiations. Go over that with Mr. Thomas, and we'll, if it needs to be on a trial, we'll put it on at the next court date.
yeah, Your Honor.
Okay, all right, you go back with the bailiff. Then you got Javian Blunt.
Yes, sir.
Davian Blunt.
Good morning, are you Javion Blunt? And this is cause number 26, VCCR 1220. Mr. Blunt is charged with murder in that case. Mr. Wilkerson has filed a motion asking that I reduce the bond, which is currently set at $1.5 million. And Mr. Wilkerson, you may proceed.
Yes, Your Honor. This case, Mr. Blunt has been incarcerated now since March. And with regard to his case, we are still missing evidence in terms of the whether or not well, let me put it this way, the person named in the indictment is apparently an alias of the actual victim. And so the concern at this point is in part, a primary concern is whether or not the state could sustain a conviction as the indictment is presently worded. That being said, Judge, a $1.5 million bond does not meaningfully give Mr. Blunt the opportunity to secure bail in this case. And so, in being reasonable with the bond reduction request, given the standard bonds for offenses of this nature, we believe a bond of $750,000 would adequately secure the defendant's appearance in court.
I need some, Mr. Blunt, raise your right hand, please, the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right.
Mr. Blunt, state your name for the record, please.
Javian Blunt.
You presently working?
No,
Oh, well, obviously you are presently incarcerated in Jefferson County Jail, correct? Are you able to raise funds either by borrowing or disposing of assets to make bond in the present amount of $1.5 million? Do you believe that with the help of family and potentially friends, if the court were to reduce bail in this case, that possibility might be enhanced?
yes, sir.
Can you describe to the court your familiarity with the area? That is, do you have family here in Jefferson County?
Yes, sir.
Are you from this area?
Yes, sir.
And have you been in Jefferson County for the last 5 years?
Yes, sir. I'm in my life.
All your life? Ever moved away?
Speak up, please.
No, sir.
Prior to becoming incarcerated, were you working?
Or if not right before, I had just not working in the Ford Arena,
Okay. How long had you been there?
a few months.
Okay. Are you asking this court in the interest of justice to reduce your bond from the 1.5 million that is presently set at?
Yes, sir.
Ask the witness, Your Honor.
No questions, this witness.
Right, any other witnesses?
No, Your Honor.
Mr. Smith, any witnesses?
No, Judge.
What is the state's position?
State is opposed to a bond reduction, Judge. It's not uncommon that bonds in murder cases are set at $1 million.
I need you to speak up too.
It's not uncommon in this court and in Jefferson County that cases for murder with facts such as these are set at $1 million or greater.
So
Like that's a sufficient bond in this case.
do you want me to take judicial notice of anything?
The affidavit of probable cause would be.
Okay, I'll take judicial notice of the court's file, including the affidavit of probable cause. Give me just a second to get that. All right, anything else?
Nothing from the defense, Your Honor.
Also, the jail records show he has disrespect for the staff and other inmates in jail while he's been.
I'll take judicial notice of, I just received a jail incident report. Has two incident reports on it from July 15th and July 9th.
And I would just note, Your Honor, that both of them involve minor infractions. It looks like being out of bunk after lights out.
Right, this time I'm going to grant the motion to reduce the bond. I'm going to reduce the bond to $1 million. There will be bond conditions of house arrest, as well as wearing a GPS monitoring device if that bond is made. All right, we can go back with the bailiff.
Thank you, Your Honor. I believe that concludes my cases until the 11 a.m.
Thank you.
Excuse me.
Yes, sir. Good morning. Are you Howard Dwayne Walker Jr.?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
It will, Your Honor.
Mr. Walker, in clause number 26, DCCR 0082, you're charged with a first-degree felony offense of injury to a child from December 16th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them, but the state's marked as exhibit number 1. Before you sign these, did you go over them with Ms. DeLage?
Yes.
Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Walker's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the offense of injury to a child. Sentence you in accordance with your agreement to a term of 22 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. DeLage. And Ms. DeLage, do you have your discovery certification?
The cert, I don't have the discovery sheet yet. I was gonna email it this afternoon. Didn't expect to get a plea today.
Yeah, if you'll get that done as quickly as
Yes.
possible and because the case has to get closed out,
Right.
then it becomes, you won't be able to get to it.
Yes, ma'am.
Okay, you can go back with the bailiff.
Thank you.
Do you want to make these?
But that's what's alleged is that and how.
Thank you.
Thank you,
And
Nancy.
may I excused?
Yes, thank you. And Mr. Parker, you've got Gabriel Cruz.
Ma'am. So.
Good morning.
Gabriel Cruz.
And I've got two
Sentences.
and a dismissal on one, is that right?
Sheriff, why did you let me do that?
He said, what'd you do? I said, I came over here, I know the judge on the page.
I knew you did. As soon as you-
I want to get him.
I mean, I thought about it.
I didn't even look.
Good progress for you.
I still think back to the day when the Boston had you said, looked in here on it.
Oh, yeah. Yeah. Good morning. Are you Gabriel Cruz the third?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment in each case?
0373 and 0374.
Mr. Cruz, in cause number 26 DCCR 0373, you're charged with a third-degree felony offense of stalking from February 23rd of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes,
And are you pleading guilty because you actually did what they charged you with?
yes.
And then in cause number 26 DCCR 0374, you're charged with a third-degree felony offense of violating a protective or bond order, and that's from February 23rd of 2026. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with? I have here on the tablet in each of those cases, some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreements that you've reached are for 10-year term in prison on each of these cases, but that would be probated for 10 years. There would be a $500 fine in each case. There would be a dismissal in cause number 26 DCCR 1060. And you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
State tenders number 1 in each case.
Objection.
It's admitted in each case. Is there any evidence that Mr. Cruz is not competent?
No, Your Honor.
And Mr. Cruz, do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State, sorry, we already did that. All right, I'm going to find, Mr. Cruz, that you entered your pleas of guilty in each of your cases freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your case for sentencing so that we can get a pre-sentence report that'll give me more information about you and your cases, and then we'll come back later for sentencing. All right, you can go back with the bailiff. Mark Hebert, Mr. Parker, it's a sentencing.
Yeah.
This crew was done.
I don't hear from this. I thought it's probation officer, the kitchen. Yes, but not.
Man, that you were talking to behind me. Is that Mr. Celestine?
No, that's the father of Hakeem Dolls.
Okay. He lives over there. I was curious.
Good morning. Are you Mark Hebert?
Yes, ma'am.
And Mr. Hebert was previously in court and entered pleas of true to counts 1, 2, 3, 5, 6, 8, 9, and 10 in a motion to revoke his probation. He's on probation for driving while intoxicated third or more. This was unagreed. I've received the updated pre-sentence report. Have you both had an opportunity to review that report?
You have, Your Honor.
Judge.
Any additions or corrections to the report?
None more, Judge.
I'm just saying.
Mr. Parker?
Judge, I mean, my intention, excuse me, was that, and what Ms. Malfina and I talked about is that he had some serious health conditions. He ended up using drugs. I don't know how long he had been using drugs in the past. He and I had a heart-to-heart talk, explaining the situation he's in, and we talked about Safe P being a great option for him. Now, his mind has changed, and I like to let him address the court, but he said being in jail, he's been in there for a while now. He said his mind's clear, and he was here before on oxygen, and he's able to breathe better with his emphysema and all the other issues that he's had. But he's indicated he just wants to take his time. And I mean, my position is that, I personally think Safe P is probably the best thing for him. But at the same time, if he doesn't want it and then why take him to bed? Ms. Bells could use it. I'd like to let him address the court, Judge.
So, Mr. Hebert, the recommendation was for potentially Safe P and to get you that help. Are you saying you don't want that?
I'd like to just go back to probation and get help from home.
Well, that's not gonna
That's
happen.
okay.
Yeah, so it's either Safe P or prison.
Safety. Yes, ma'am.
So here's the thing about Safe P. It's an expensive program. And I don't want you to, kind of like what Mr. Parker said, go just take up a bed and we pay $70,000, $80,000 for you to go and you don't get what you need out of it. If you don't go in with the right mindset, then it's going to be a waste of everyone's time. If you want that help, I'm willing to give it to you.
Yes, ma'am. Please.
Ms. Malfino?
And if I may respond to one other thing, I think part of his attitude was when he did the PSI is that he was like, I'm on drugs. And I think maybe now that he's been there, he's cleaned up a little bit and not on drugs and realized that the help, he really needs that. And
Yeah, I mean, you
That's why
tested
it's-
positive 1 month after having an
Mhm.
angioplasty and a stent. You started using drugs again. So obviously you need some help
Yes, ma'am.
if you're doing that 1 month after that kind of scare. So,
Yes, ma'am.
Ms. Malfino, anything to add?
No.
So, Mr. Hebert, I'm going to give you this opportunity and I hope you take advantage of it. I'm going to find that you entered your pleas of true, freely and voluntarily, find all of those counts true, find sufficient evidence to revoke your probation, but I'm not going to do that today. I'm going to continue you on probation. Let's see, you were put on in September 25. I'm going to order that, as a condition of your probation, you enter and successfully complete the safety program. If there are still ongoing medical needs, then they'll put you in the special needs safety to make sure that any of that's taken care of as well. So I'll let them determine which one, but it probably would be the special needs if you're still having some ongoing health issues. This is your opportunity to get clean, live the rest of your life, finish your probation and not go to prison.
I appreciate it. Thank
You're
you.
not going to get an opportunity like this again, so take advantage of it.
Yes, ma'am.
So this was not an agreement. So I'm going to hand you the trial court certification. You have some rights to appeal. Can't imagine that you would since I just did what you asked me to do, but here is, if y'all will sign the bottom and then just give him the bottom. Brent Smith,
Thank you, Judge.
that one.
Yeah. Yeah.
Good morning. Are you Brent Smith? And this is cause number 26 DCCR 0128. Mr. Smith was previously in court, entered a plea of guilty to burglary of a habitation. It was an agreement. I've received the pre-sentence report. Have you both had an opportunity to review that report?
Yes, Your Honor.
Yes, Judge.
Any additions or corrections?
None more, Judge.
Not from the state.
So. My concern here is the drug issue and the type of drug specifically with PCP, and I'm not real sure that. I'm just considering potentially ISF for some treatment.
That was part of the recommendation.
I don't see that. I thought it was, I don't,
If
ISF substance abuse.
it was part of the,
okay, well, it's not on here, but that's what made sense to me, so,
Yes, ma'am. That was part of the deal. That was
Okay.
the only reason probation was
Yeah.
offered in this case.
okay. Got it. All right, so Mr. Smith, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney's office and defer all proceedings, place you on probation for 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That is going to include entering and successfully completing the ISF Substance Abuse Track Program. And then once you're released from that, you'll be on the specialized mental health caseload and be required to follow all of the rules, all of the recommended treatment, including medication. Whether you feel like it's something you need or want, if they recommend it, it's going to be part of your probation that you have to follow all of those rules and recommendations. Do you understand? It looks like any other follow-up treatment from after ISF. And obviously you are to remain away from 4325 Galveston Street. You cannot be anywhere near that location. Do you understand? All right, I'm going to hand you the trial court certification. It shows this was an agreement that I followed and you waived your right to appeal. You're very lucky, sir. Because the house that you broke into, most houses that you break into nowadays, you could end up with someone taking care of that on their own, especially if you enter into a law enforcement officer's house and traumatize them and their family. So you understand the seriousness of this. So if you do everything you're supposed to on this probation, this is a great opportunity. You don't have the conviction on your record. We're going to get you the help you need. You can be successful. But the other side of that is if you violate any condition of probation at all, you will be back here in court. You could be found guilty of the offense and sent to prison anywhere in the range of punishment, which is between 2 years and up to 20 years. Do you understand? All right, and go back with the bailiff.
thank you, Judge. Yeah.
Mr. Rojas and Hillary Davis.
Davis.
David. How are you?
Clients here.
Oh, yeah?
Well,
This one?
not this one.
Oh, you've got that one. I heard it. I heard that we had to deal with that today.
This one's easy.
You sit down that last one.
Good morning. Are you Hillary Davis? And Mr. Rojas, will your client waive the formal reading of the motion?
She will, Your Honor.
Ms. Davis, in clause number 23, DCCR 1551, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation March 11th of 2024 for credit debit card abuse, state jail felony, and that was a 5-year deferred probation. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you committed the offense of possession of a controlled substance, penalty group 1-1B, April 29th of 2026. And is that true or not true?
True.
Count 2 alleges that you failed to avoid persons or places of disreputable or harmful character, specifically that you were at a place where a criminal act was being committed and you were accompanied by a co-defendant named Jonathan Rito. Is that true or not true?
True.
Count 3 alleges that you failed to work faithfully at suitable employment and provide verification of that to probation. Is that true or not true? Sorry. Count 4 alleges that you possessed a drug, cocaine, April 29th of 2026. And is that true or not true? Count 5 alleges that you admitted to your probation officer that you used illegal drugs, marijuana and cocaine, April 21st of 2026. And is that true or not true? Count 6 alleges that you failed to never become intoxicated or under the influence of an intoxicating substance, and that you tested positive on April 10th of 2026 for cocaine and marijuana. And is that true or not true? Count 7 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true? True, you said, I'm sorry? True. Count 8 alleges that you were at a location other than your residence at approximately 1:56 a.m., April 29th of 2026. Is that true or not true? Count 9 alleges that you are behind in your payment of restitution as of May 19th, 2026 in the amount of $297.50. Is that true or not true? And then count 10 alleges that you failed to pay court assessed fees as directed, and as of May 19th of 2026, you're $2,128 in behind. Is that true or not true? Did you enter your pleas of true to counts 2, 3, and then 5 through 10 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? Yes, ma'am. And do you understand if I follow the agreement that you've made with the district attorney's office that you'll be waiving or giving up any right to appeal? Yes, ma'am. And it looks like that agreement is for a cap of 18 months in the state jail prison, which means we'll come back. I'll get an updated report from probation, have a hearing on sentencing at a later date. As long as I give you 18 months or less, then you're waiving that right to appeal. Is that what you want to do? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Davis is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered the pleas of true to counts 2, 3, and then 5 through 10 freely and voluntarily. Find this counts true. Find sufficient evidence to find you guilty and revoke your probation. I'm not going to do that today. I'm going to reset your case for sentencing. Ask the probation department to do an updated report. Anything that you think is important for me to know, get that information to Mr. Rojas and he'll present it to me on your behalf when we come back. All right, you're welcome. You can go back with the bailiff. Do you anticipate a hearing, any information with regard to count 1? Are you gonna?
Judge, it's a drug case and labs probably haven't even come back yet.
Okay. I mean, that's fine. She's
I'll
meant
try.
everything else, so.
Got to get the ultrasound. If they do your neck test, I can provide.
If you think you're gonna get it, just let us know. We can do it at 11 o'clock or something, but up for now, we'll just do it on a regular docket. Thank you. We need to take up before we bring the jury in.
Or in reading the indictment, do you want me to stop after each paragraph to allow the defendant to make a, enter a plea? Or just read both paragraphs?
I think because, thank you, ma'am,
Uh,
because
My thinking was to stop after each paragraph.
I think that would probably be correct, because technically he could be found guilty of one or the other. Not both, though, just one or the other.
Well, my thinking. I was going to argue to the jury, they don't have to be unanimous in which one.
I think that's correct, maybe, but I'll have to,
I don't think so.
We'll cross that bridge with you to it.
well, but if it's gonna be if you're gonna say that in your opening statement, okay, then I'll do some research on that. So I would say, let's just read, stop at paragraph 1. It's not gonna hurt anything to do it that way. I think that's the cleaner way, just in case, and that way we don't have to go back and do anything. If it ends up being that it's one or the other or anything like that, and then obviously at some point, if there's anything, and if you took a look at that and you're good with the way it is, I'll try to figure out the charge. I'm gonna need some help. If you want to do anything to change it, then just let me know at the proper time and I'll reevaluate the charge. I do have a proposed already. I'll send you guys, y'all can start taking a look at, but it could be much different depending on how that goes. Anything else then before we bring the jury in?
My standard motion to eliminate judge, I don't know if you ruled on it.
I know, I thought you did yesterday.
I think
Okay.
you didn't have, I ruled on yours and,
And I think you said if he's gonna bring up any extraneous offenses to approve.
either of you, yeah, and really for the motion and limines, as far as I'm concerned, that everything in either of them goes for both of you. If anything comes up that either of you think becomes admissible or relevant, just bring it up to me outside the hearing of the jury. And then I did listen to what you guys requested me to listen to with regard to the body worn camera of the officer and the Miss Ballard, I think is her name's, statements on that video. And, Mr. I guess for the record, go ahead and make,
Judge, I'm gonna object to the tender of the statements of Ms. Ballard on the grounds, one, that they're hearsay. And if the court finds that they are within a hearsay exception, I'm going to object under Crawford versus Washington, because I think I'm entitled to cross-examine her regarding those statements.
Mr. Coleman.
It's clearly an exception to the hearsay rule, Judge, and as such, the fact that she is still under the excitement or the effect of the that stressful situation when she makes those statements, make it squarely an exception to the hearsay rule, which renders it admissible as evidence in this case.
I'm still entitled to cross-examine her under the confrontation clause and Crawford versus Washington. I mean, if she comes and testifies, that's fine.
Felt it sneeze. Shoot. I
Water.
was about to sneeze. Let's do this. This is your second witness, you think, or your first witness?
Second.
All right, so I'm going to hold on making that ruling right now. I have no issue at all with making a finding that it falls under an exception. She is clearly, I think it could probably fall under number 1 or number 2 with regard to present sense impression, or excited under its, in my opinion. With regard to the confrontation, I need to do a little more research on that, and I'll make that decision before that next
I would
witness.
direct the court to Crawford versus Washington.
Yeah, I know. Anything else?
Not from state, Judge.
No, ma'am. How long would either of you request for opening?
5 minutes.
Very brief, Judge.
All right, you can bring the jury in.
Man,
What's your email?
W Bradford Jr.
Got it.
At AT&T. No. Yeah, that's great.
Good afternoon. Let the record reflect the jury seated, state's attorneys present, defendant and defense counsel are present. And at this time, ladies and gentlemen, I'm calling the case of the state of Texas versus Joseph Charles Freeman, cause number 24 DCCR 0348. And I'm going to ask you all to please remain seated, but raise your right hands to take the oath of the jury. Do you and each of you solemnly swear or affirm that in the case of the state of Texas against the defendant, you will a true verdict render according to the law and the evidence, so help you God? Thank you. And is the state ready to proceed?
State ready, Judge.
Defense ready.
Yes, ma'am.
Do either of you wish to vote the rule? Do we need to?
Yes, ma'am.
So I need to get any witnesses that are available down here real quick so we can get that taken care of, please.
All right, all witnesses, but if you say for, you never do that.
No.
And obviously, for each of you, if you have any witnesses who aren't here, make sure to admonish them about the rule of being in the courtroom and specifically about watching anything on the YouTube channel.
Yes, ma'am.
Yes, Judge.
Any others upstairs, or is this what you've got right now?
This is all I have for
Okay, would all of you please raise your right hand? Do you and each of you solemnly swear or affirm the testimony you're going to give in this trial will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. The rule's been invoked, so you know that means you can't be in the courtroom during anyone else's testimony. Don't discuss your testimony with anyone else involved in the trial, and don't watch any of the proceedings on YouTube. All right, thank you. Y'all can step out. All right, Mr. Coleman, you may read the indictment. Mr. Freeman, if you'll please stand up.
In the name and by the authority of the state of Texas, the grand jurors for the county of Jefferson, state aforesaid, duly organized as such at the January term AD 2024 of the Criminal District Court of Jefferson County in said county and state, upon oath in said court, present that Joseph Charles Freeman hereafter style, the defendant, on or about the 27th day of March 2022, and in anterior to the presentment of this indictment in the county of Jefferson, the state of Texas. Paragraph 1 did then and there intentionally and knowingly cause the death of an individual, namely Richard Shiloh, by shooting Richard Shiloh with a firearm.
And how does the defendant plead?
Not guilty.